come to our talk for this afternoon. Beyond just a subject, beyond just a course, I think that it's important for us to recognize that it is important, in particular for businesses, and in fact, it's important for us as well as individuals. And oftentimes start off such talks by making this particular statement, which is this, that not a single person would be unaffected by intellectual property. In other words, you and I, we are affected by, we're involved in IP. As one very simple example perhaps, right now, as you are looking at the share screen, and I believe you can see it now, you're already seeing one aspect of intellectual property. It's a Saturday afternoon. Let's have a bit of fun and chit chat, and I'm going to engage you this afternoon. I want you to type into the chat function and let me know what is it that you're seeing on your share screen that you think comes under intellectual property. As in, what part or which part of IP would you think that what you are seeing on your share screen would involve? Very good, Hazrik. It's copyright. There you go. One of two things. Either if you were to take this image or these slides and you share, then I may perhaps sue you for infringement of copyright because you are taking my slides. Of course, I must also give a confession right now to all of you. I took this picture from the internet somewhere, and so whomever I took it from, this picture you are seeing, they can potentially sue me as well for infringement of their copyright because it's their picture, isn't it? And so there you go. As simple as what you're now seeing on your share screen, you're already seeing one example of how IP affects you and I because we use such kinds of images and slides, for instance. Now, of course, you may say, oh, but David, that's you, not me. I don't use slides. Well, perhaps, but let's think further. In the course of your work, have you prepared slides for a business presentation? Have you included in your slides or proposal or your business presentation images, quotations from people, extracting or copying and pasting some materials online into your slides, into your proposal? Because if you have, that would be copyright. Let's do another simple activity. This time, look beyond your share screen. Look around you. Okay? Now, I am not there with you. Your videos are off, so I can't see you. But I would like to invite all of you to look around you, and maybe both of you can share with me. What do you think that you can see around you that has some intellectual property protection, and what that would be? I'll give an example, okay? Right now in front of me, I have my handphone. My handphone, it's what I have with me and you have them with you all the time. What is the intellectual property? Anyone can tell me. For a handphone, what IP comes along with a handphone? Obviously, Apple or whatever other handphone brands would want to assert certain intellectual property rights over a handphone. Can I ask, what would you think the intellectual property rights could be for a handphone? Very good, Hazrik. A patent, okay? The technology behind that invention. And so that's IP. Okay, so again, I want to invite both of you, all of you, look around you. What do you see around you? No cheating, you can't say handphone because that was mine. What else would you think that you see around you that you think might have some IP? Anyone wants to try? Hazrik, since you are doing so well, I can perhaps invite you to start off. Okay, very good. Zoom, the name itself potentially could be trademarked. But I like the fact that you considered the possibility of copyright, because we have had cases where they tried to copyright a word, but that was not too successful. In fact, out of interest, if you want to, there's a case called Exxon, and that was where the company tried to apply or to assert a copyright over their name of their company called Exxon, and in that case, it failed. It failed. So therefore, if Zoom were to try to argue a copyright over their name, they will fail. If Exxon can fail when it's a fairly interesting created name, fictitious invented name, if that can fail for copyright, all the more Zoom will fail for copyright. Such an ordinary word. But yes, Zoom itself would be one for which can be successful. In relation to the earlier answer given by Hazrik, trademark, very good. And you are all working for employers, for businesses and companies. Wouldn't your company want to trademark their product name? Wouldn't the company want to trademark their business name? Like Zoom, perhaps. And so one more illustration to confirm how we are surrounded by IP issues. And today's topic in particular, of course, is for sustainable business. We need to have a strong trademark over our business name. We cannot afford to have some copycat company somehow later coming on to copy our trademark name. If they do, we will sue them. So Davinci Code says Zoom has become a Me Too virtual session. I'm not too certain what I understand by that Me Too comment.
Okay, David, I mean it's okay. When people say have a virtual session, right? People always say it's Zoom.
Okay. Understand. So it's become like a normal term, right? Generic label, is it right?
Yeah, it's a Me Too. I mean, like, but I don't think that's right, lah. But is that the infringement, or is it Zoom will be happy? You know, people say, yeah, I don't care as long as you use it like a kind of promotion. I mean, a kind of a free promotion.
Yeah. Okay.
Or generic label, I call it free, lah. You know.
Okay, good. I'm glad you brought it up because that is part of the discussion that surrounds trademark and trademark law. And the point that you are making, which is correct, if I understand you correctly, is that certain names that are ordinary, in particular where they are generic, ordinary label, where we refer to it to refer to, say, for example, a virtual session. So whenever we use the word Zoom, we actually use it to refer to a virtual session, and it may not really be Zoom, right? It could be using Teams. It could be using Google
Webinar?
Meet. Sorry?
Yeah, but like webinar?
Yeah, correct. Yeah, webinar. But yet we use Zoom, right? And that point is a good point because why? I can now share with you this additional fun fact, which is this. A trademark will fail if it becomes generic. Which means even if Zoom had been successful as a trademark, in time to come, if they're not careful, someone can apply to remove their trademark. Many people think, oh, if I have a trademark, I'm set. It's mine forever. That's a wrong perception. Again, today's topic is very meaningful. Our title for our topic is Sustainable Business. Using Zoom as a trademark name, in my opinion, is not the best of names to choose. It is not a sustainable trademark. Because the moment that word becomes generic, we refer to Zoom as a webinar, as a virtual session. It becomes generic. We say, oh, let's Zoom. But they don't mean Zoom. They use something else, another platform. When that day comes, someone may challenge Zoom as a trademark. In fact, on that note, the other example I can give you, which is a, in fact, better example of a dangerous trademark that may fail one day, is Google. Today, when we do an internet search, what do we say? Let's Google for the material. Let's Google this, let's Google that. But we are not perhaps using Google. You're using Safari, you're using Mozilla, Firefox, Microsoft Edge, you're using another search browser, but we use the word Google. Google has become a verb. To search for something online, we use the word Google. It's become a verb. No longer a trademark. It's become a generic label. And that, in relation, is where Google may one day also have a trademark revoked. Not only Zoom. Zoom itself is even ordinary to begin with. Very dangerous. Even Google, where it's an invented word. Google is not an ordinary English word. Even that may be susceptible to failure. It's again, perhaps not sustainable. Google and Zoom, in some sense, it's a victim of their own success. Too successful. So part of what intellectual property is about is, apart from understanding what the law is, but to understand how to utilize it effectively to sustain our businesses, to make it protectable, right? That's right, as patent has a lifetime. It's 20 years, yeah? It is not forever. The only one trademark that's forever, since we are now pivoting to a discussion of the duration, that's right, patent, it's for a finite period, it's for 20 years, but you find that for trademark, it is forever. And that's why we are very careful. Trademark is forever, as in that you renew, you renew your trademarks every 5 years, for instance. But so long as you are using it, it's not challenged by anyone, in general, it will be renewed. Okay? The way I teach is trade secrets. Okay? Well, to be fair, it's not. I would like to, Hazrick, thank you very much. I would like to make my way of teaching to be a trade secret, but it's not a trade secret for one very simple reason. Right now, this is in public. Trade secret means it must be secret, you know. The very idea of protecting something under trade secret must be secret. The moment I show it, I do it, it's no longer a trade secret. So, too bad for me. But taking now trade secret as the last point allows me now to show you my next slide. And let's carry on. And feel free, by the way, guys, to make your comments or questions. I think we want to make our Saturday afternoon meaningful, beneficial. Whilst this is a talk that is conducted by us at Kaplan, at the end of the day, we really want you to be enriched. If you do enroll for the course because you want to learn more, and I think why not is a great idea, good. But even if not, doesn't matter. At the very least, you benefit this afternoon. Let's not waste this afternoon. It's a precious time. And I want to now carry on to show you some additional things. So Hazrick mentioned trade secret. There you go. I mentioned copyright. There you go. And trademark was mentioned, Zoom, Google, there you go. My Apple handphone example, patent, there you go. Not just that. Just now I asked you to look around your area, right? Now let's now go back to the question. Can anyone tell me what is around you right now that you're seeing that you think may perhaps have a design right? Look around you. What do you think you see that potentially may be a design that the manufacturer or company may want to protect using this IP right called design right, which is part of our intellectual property rights? USB-C, very good, okay? Although they will fail, okay? And that's because of some principle within that design right law. But yes, that's a good thought, right? It's a good thought because it has to be designed like that to fit into your laptop. The design to be like that to make it functional, not like the older USB design. This is a new USB-C design, and it's supposed to be better, more functional, faster perhaps, more durable, and all the benefits of a USB-C design. That's a good thought, and yes, potentially it might come under design right, but it will not. as the white will not, this one you must register with Kaplan before we tell you the answer, okay? No, okay, someone else. What would be another example of a design right? Anyone want to try? Those who have not given any answer so far, I think we have Hazrik, then we have Namkok. Namkok, what do you think? You seem to be quite knowledgeable as well. What do you think could be what you see around you to be a design right? Any interesting designs or products that you see around you?
I think it's go back to the handphone.
Okay. Okay.
Of course, you see handphone now we're using the normal, you say that just, but Samsung is coming out with like the tablet become a
The
handphone.
two-screen one, huh?
Yeah. So is it a design right, or they're trying to say this is what we want it to be for the future? But whether successful or not, I'm not sure lah.
Okay.
Okay.
Excellent. Very good. I think the examples are correct as well. Handphone. Now, of course, the typical rectangle handphone that's very ordinary, like the current iPhone 12 or 13, that one a bit tricky lah. But the idea of a design for a handphone is correct because potentially the design for a handphone can be quite varied with different varieties of. Some of you, if you are perhaps my generation, you may remember that Nokia had a banana-shaped handphone. Anyone? You lived through that era? That Nokia had a famous banana-shaped handphone. There you go, Hazrik. Okay, I know how you are lah. I know how you are, okay? How old you are now? Now, isn't that something worth protecting? The banana-shaped handphone by Nokia. Then Motorola had the flip phone, right? My first phone was a Motorola, and it was a flip phone. The design. Then with that comes Namkok's answer, which is in relation to the current Samsung tablet foldable phone. The design. You are absolutely right. So if I'm Samsung, and then some joker come along to manufacture a similar tablet like that design, look like mine when I came first, I wouldn't like it. We want to have our products, our businesses to be sustainable. Intellectual property goes a long way. And now, that's right, you have it, okay? Where it is also design right. Now, I have 5 here. These are the 5 core rights, but there are a few other lesser ones. But these are 5 main ones that you are familiar with and that we've discussed. Now, with that, let me carry on. And since all of you are doing so well in participating, it's just nice that I prepared this. I want to now give you a test, okay? If you can answer these questions, then you are eligible to do the Kaplan course. Otherwise, cannot, okay? Disqualified. This is like an entrance exam. No lah, joking, okay? Can anyone tell me what IP issues there are that you are seeing on your share screen? You can unmute or type in the answer, whichever you're comfortable with. If your sound background is appropriate, not distracting, feel free to talk to me as well. But what IP rights would you think that you see? Design right, okay? So you are seeing, very good, right? I was expecting the answer that you will give will be where you will say trademark. Because you see either in the name or it could be the logo. Am I right? So that was the initial answer I thought you will give me, which is, look at the logo. Look at the name. Okay? But Hazrik is, of course, the good student, the good IP student. Design right. Because you are seeing that these chocolates has a special design. However, it will not be designed right or it can be, these two cases are famous for another IP right, which not many people are aware of. These two cases, these two brands are famous for an aspect of their shapes, and the issue is whether or not shapes can it be a trademark. These are two trademark cases. Both of them applied for a trademark because it's very recognizable. You see Toblerone, you see Kit Kat, you know the brand name. You will know it's a Kit Kat, you will know it's Toblerone. So both these companies have tried to apply for a successful trademark. Only one company was successful, and it was Toblerone. Kit Kat has been trying and trying and trying. They've had about, from what I recall and counted, 3 failed attempts. One day, they will be successful. And I'll tell you why if you enroll with us for the course, okay? But for now, they failed, right? So for now, they failed. Now, for today's purpose of a preview, I don't want to go into details of why they fail or why they're successful, but suffice, and the main purpose of me showing you this slide is to show you how shapes can be a trademark. And today it is true, isn't it, that for a business to be successful or effective, we need to bombard and market our product to our customers from a multi-sensorial experience point of view. It's not just seeing the name, it's seeing the logo, seeing the slogan. The slogan for Kit Kat. Anyone? What's the slogan for Kit Kat? Any chocolate lovers here? What's the slogan?
Take a break.
Yeah, correct. Take a break. We want to trademark the slogan. We want to trademark the shape. And so a sustainable business is one that will experience or will get the customer to be engaged in a multi-sensorial experience. In fact, not just that. I don't have it here with me in my slide, but let me give you one more before I move on to my next slide. What about sound? Do you think that a sound is something that we may want to trademark? Let me give you an example. I was at a friend's house the previous year, and his son was, I think, 3 years old, toddler. And so we were out in the living room, and I think there was a TV advertisement that came along, and it was McDonald's. McDonald's has a very famous jingle. Can anyone remember or your mind imagine the jingle? If I ask you to give me the jingle, you could be shy lah. Let me do it for you. The jingle for McDonald's is pa 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 pa. Yeah. Okay, I don't have good voice lah, but that is the jingle. Ta 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 ta. Now anyway, the son was in the room playing. Did not see anything. When he heard the music, when he heard the sound, he came running out and said, McDonald's. McDonald's has been successful to market their business, their product, not only using their mascot, their trade name, their logo, their slogan, but even their jingle and a sound, so that when you hear it, you think of McDonald's. You see red and yellow, McDonald's. You see a clown, McDonald's. You see the slogan, which is what? Just loving it, McDonald's. So, a business will want to market itself to us using different aspects of their product. And all this comes under trademark. Okay, so with this, right, let's move on to some other examples. Still to stay on a little bit here on trademark. Again, another question. Can anyone tell me, when you see these two colors, let's start with the first one. What comes to mind? What is the product that comes to mind when you see this color? I did this session one time previously, and someone told me, Barney. Barney the purple dinosaur. No, not Barney, okay? Another one. This is for, I give you 3, sorry, a chocolate. I unwittingly showed you the answer, chocolate. Is it true? If I ask you, right, for a chocolate, what brand comes to mind? You will say Cadbury. Okay, let's try. This is now for jewelry. Suppose that you are at Takashimaya and you see someone living or holding this color carrier bag. You don't see the name, but you will say, oh, he or she just bought something at Tiffany. In fact, Tiffany is so famous in its color, we call it Tiffany Blue. That's the name, Tiffany Blue. So if someone were to try to sell jewelry, let's say, Pokong, or I don't know what other jewelry company that you're familiar with now, right? Gold Heart. If they sell jewelry with this color, would you think that Tiffany would like it? If this company XYZ sells chocolate with purple color, would Cadbury like it? This will be the issue of whether can colors be a trademark. Can the color be a trademark? Okay, that's part of your IP issues. And again, don't companies have colors in how they present their business? Look at our local companies. You may say, oh, Mr. Chang, these are overseas brands. Well, to be fair, they are here in Singapore, aren't they? Let's look at local brands. Our 3 telcos, Singtel, StarHub, M1. What are their colors? Anyone? Singtel, what color is Singtel? Singtel, what color?
Red.
Red, very good. StarHub, what color? StarHub. No StarHub.
Green.
Green, that's right, okay. So it seems that StarHub not very popular lah. M1, what color? Orange, yeah. For the fact you all can name me the colors, tell you what, colors are important for business. And if colors are important for business, how do we protect the color? Trademark. Okay, with that, let's move on. Otherwise, I'll take the whole 1 hour. So let's move on to look at some other IP issues. This is easy. We know Adidas, the 3 stripes. But did you also know that over the years, there have been 2 stripes product, there have been 4 stripes products. Adidas obviously have been suing them. Okay, this is a real case. At a passing glance, Adidas. Adidas wouldn't like it. What about the next one? Starbucks. Starbucks has so many competitors of people copying the logo. I'm sure you have seen this if you travel to China. Have you seen this even? Okay? Starbucks wouldn't be too happy. Now it could be where they will say it's a parody, it's a joke. Surely we don't mean this. And I won't say the word here in case your family is around you. But Starbucks wouldn't like it. You are trying to, despite the fact that you are clearly not Starbucks, people will go there for the fun of it, take picture. You know what I'm saying? You know it's not Starbucks, but you still go there. So this other company is riding on Starbucks fame to get or divert customers to themselves. Even though they are not Starbucks, the public will not be confused. We know it's not Starbucks, but we will still go there for the fun of it, take a picture perhaps, the novelty of it. Starbucks wouldn't be happy. Intellectual property issues in business. Many of you know this particular movie, the famous actor of Tom Hanks in Davinci Code, right? Quick answer, does IP work enforceable in China? Answer is yes, it is. Number one, they have good IP laws. But the issue, of course, which I think you are asking, which is a correct question, is even if it's IP law, is it something that is being enforced or enforceable? Actually, the answer is also yes. There is a perception by many people thinking, China, a lot of copycats, you lose your rights. Now, not wrong, okay? Not wrong. China has a lot of problems, I understand. But I can tell you for the fact that the authorities are working on it. You do a Google, the word Google, you do a Google, and you'll find that they have been taking a lot of these companies to task, prosecuting and enforcing the IP rights. So many. So the answer is yes, right? It is workable and enforceable in China as well. Now here, back to this slide. We know the movie by Tom Hanks called Davinci Code. What you may not know is this. The publishers copied large parts of the movie or the book from an earlier book called The Holy Blood and Holy Grail. If you have watched the Davinci Code movie, which is based on this book, by the way, called by Dan Brown, it revolves around this conspiracy theory about how Jesus Christ was married, how he had children, he had descendants. It was all covered up by the early church. It's a conspiracy, and then there will be a group of people who would guard the secret, and will not let anyone know about it. And so there were a lot of key themes or concepts about that movie, about the book. What many people don't know is this. Of about 23 themes, 23 concepts, 21 came from the other book, or other was copied, okay? So the Holy Blood and Holy Grail had 23 key themes. Dan Brown copied 21. And so they were sued for infringement. This, of course, as you know, it's a case involving copyright. Okay? But of course, to give you a conclusion and closure for this, it was not successful. I may copy your idea, but did I copy your expression? This is something that you learn in our course for IP, and this is important. People think, you copy. Yes, I copy, but what did I copy? I copied your ideas. I copied your themes. You have a theme about Jesus Christ having married and have children. I copied that. But can you sue me for copying an idea? Like the way I teach, Hazrit. However it is that you think I teach. Someone may copy me. The way I move my hands, the way I say my words. Can I sue them for copying me? Well, we do say that imitation is the best flattery. Now, all I'm saying is this. Not everything you copy, you can sue. In this case, it was a famous copyright case, but in conclusion, it failed. As to why it failed, again, this one you must enroll with us. Then I'll share more with you, okay? But in closing, because we want to move on to the next part of our presentation today, one last one. This one, I will ask you the question. Can anyone tell me what IP right comes to mind for these two famous companies? You answer correctly, then you qualify to do the LLM course. Anyone, what comes to mind? What possible IP right would you think that they may argue or that they have? KFC and Coca-Cola. That's right, Hazri. Okay? Trade secrets. Now, trademark, of course, but I was looking for trade secrets. You're right. Trademark is obvious, trademark. Trade secret. Colonel Sanders' 11 secret herbs and spices. Coca-Cola. Till today, allegedly, no one knows. No one knows, but the public does not know what the contents are, the real contents are. That comes under our syllabus for intellectual property. Last but not least, of course, would be your patent. Okay? Patent is the one IP that is worth a lot of money. You can look at the figures here. a little bit to give you a sense of the importance of protecting your invention. IP is important for business, important for us. What I said at the beginning of our session. Now, the fact is that IP runs through a business cycle, but this one I won't go through with you. Perhaps if you were to enroll the course, I will give you more details, but briefly, right? From the beginning of an idea to when you express your idea, to when you develop your product for the idea, to when you set up a business to run your idea and sell your products, to when you make contracts to begin to promote and market your products, to when you manufacture your invention, we have IP. No business can be successful nor sustainable without IP. Okay, so I'm just trying to give you a quick run through of the business cycle for IP. Then with this, we have a few final slides as I begin to wind down, and I'll take questions at the end of the session afterwards. So I see your comment there, I'll answer you. There's so many reasons why intellectual property is important. And I think you know this. You don't need to be here to know this. But of course, you need to enroll for the course to learn more. So here's a summary. And the people who generally would want to know IP, you know, I often hear people say, hey, David, I'm not a scientist. I'm not an inventor. I don't need to know IP. Really? If you are a marketeer, you want to know IP. You are a businessman, you know IP. If you're a blogger, you want to know, can you take people's picture? What if people take your picture? You take your photograph. Right? You want to know about IP. It's not only about these people, but even all these and many others as well. Intellectual property is really for anyone, not just a business. So long as you want to protect your idea, where from the idea itself to the expression of the idea, all the way to your commercial exploitation. So here would be where we use trade secret to protect. Here we may use copyright to protect. Here we use a patent to protect. IP has different types of IP, for which regardless of the types of IP in different sectors that you and I are in. Now, of course, today's a short session, but if I were to take some time to ask all of you individually to share how IP affects you, I'm certain you have a lot of things to tell me, because IP does affect you. It's whether do you realize it or otherwise.